Welcome to the Savvy Investor, where it's our job to help you be secure in any economy. One of the most often ignored aspects of retirement planning is estate planning, and today we're going to help you get your estate planning in order.
Welcome to the Savvy Investor. Each week, the Savvy Investor helps viewers just like you create and grow wealth, protect and preserve it, and distribute it in the most tax-efficient manner while alive and after you passed. Our goal is to make you a better informed investor that hopefully leads to better results, but certainly less risk along the way. You can have financial security in any economy. Today is the day you can take control of your financial future and eliminate worry about your retirement forever. And now, the Savvy Investor with your host, Michael Canet.
Today on the Savvy Investor, we're going to be addressing estate planning issues, specifically the documents that each and every one of you must have to have a proper estate plan set up. We're going to discuss wills, powers of attorney, advanced care directives, and trusts. And it never ceases to amaze me how little attention is paid to this very, very important detail. The fact is that failure to plan can result in literally hundreds and thousands of dollars of added expenses and delays between probate fees, lawyer fees, taxes. Failure to plan can be just an astronomical expense, and it can be very, very detrimental to your family. So we're going to talk about the things you need to do today to make sure you have a sound estate plan. Now, before we get there, we're going to talk a little bit about some news. Now, from the Wall Street Journal, everybody knows that the estate tax was extended at the end of 2012. And here's this tax. Everybody was afraid of it. It's $5 million per person. And here's the deal. People think now that it's $5 million, I don't need to do tax planning at all. And the fact is about 2/3 of the states have an estate tax. And we see this all the time. Lawyers fail to plan for the local and state estate tax. So just because you don't have $5 million in your name doesn't mean you don't need tax planning. And the Wall Street Journal points that out very, very specifically. And from the Capital Gazette, there's a great article about estate planning is only for wealthy people. And again, this goes back to the same article we just alluded to with the Wall Street Journal. People think that if they don't have a large estate, if they don't have more than $100,000 or $200,000, that they don't need to do estate planning at all. And that couldn't be further from the truth. Even Forbes has a great article out there about the 10 myths of estate planning. And people think that one of the biggest things is that I'm too young. I don't need to do any estate planning. The fact is that it doesn't matter how old you are. If you have assets, if you care about your family, you need to start estate planning as soon as you can. You need the simple will, you need basic powers of attorney, and you need an advanced care directive, because those are the documents that are going to make sure that somebody can help take care of you if you become incapacitated, and who knows how old you're going to be when that happens, a stroke, an accident. It talks about how your assets get from you to your loved ones. That's the basic tenets of a will. It doesn't matter how old you are. You need one of those if you own a home, if you have a car, if you have a 401k. And the Wall Street Journal and the Gazette and Forbes all point out there's things that each and every single one of you need to do on a day-to-day basis to make sure your estate plan goes in the direction you want it to go. Now, we're going to take a quick break, but when we come back, we're going to be joined by Chester Hobbs. He's an estate planning guru, and he's going to lay out the things you need to know to make sure your estate plan is in order. You're watching The Savvy Investor, and we'll be right back.
If you're in retirement or retiring in the next 3 to 5 years, you must read Michael Canet's best-selling book, Surviving the Perfect Storm. Best-selling author and National Quill Award winner, Michael Canet's Surviving the Perfect Storm is a must-read to prepare for your golden years. This amazing book can be yours absolutely free, but you must call 800-787-SAVVY. Supplies are limited, so be one of the first 25 callers to receive your free limited edition autographed copy of Surviving the Perfect Storm. Call 800-787-SAVVY. Join the host of the nationally syndicated TV series, The Savvy Investor, and best-selling author Michael Canet for this very important, life-changing workshop. Michael and his team of advisors from across the country have been helping families create and live the retirement they envision by carefully crafting a retirement income plan that can withstand any financial crisis. Michael will give you the tools you need to make sound investment choices and help you prepare for your golden years. At this workshop, you will learn more than just where to invest your money. Michael will also share tax strategies that can save you and your family thousands in tax dollars. You will learn important estate planning techniques that can help you avoid the high cost of a nursing home, as well as reduce or completely eliminate any estate tax. Now, you can join him in person for these very informative workshops. They could be the answer to creating a safe and secure retirement you deserve. Call 800-787-SAVVY to see if you qualify to attend one of these workshops with best-selling author Michael Canet, host of The Savvy Investor.
Welcome back to The Savvy Investor. Estate planning is one of those things that's often ignored and overlooked and can have dire consequences. Do you remember Terry Schiavo down in Florida? What happens if you don't have a proper estate plan? Do your assets go to the estate for failure to plan correctly? Ignoring estate planning is like ignoring your retirement plan, your health. It can have dire consequences. And today we're joined by Chester Hobbs. He's an estate planning guru, and he's going to lay out those things that each and every one of us need to have in order to accomplish your estate planning goals. Chester, welcome to The Savvy Investor. How are you doing today?
Terrific. Thanks for having me back.
So there's some basic documents that each and every one of us needs to have when it comes to retirement planning and estate planning. And so the basic documents, the starting point, what do people need to know?
Well, they really need to have a will in place, particularly if they have children, because that's the best place to appoint guardians for your minor children. There's also many tax advantages that you can take advantage through proper will drafting. In addition, they need financial powers of attorney. Given current state of Maryland law, I recommend two separate financial, but at least one financial power of attorney, a medical directive where you appoint a healthcare agent, your healthcare spokesperson, and a living will where you state to the world what your final wishes are. That seems to me to be the very basic thing that everybody should have. And then after a discussion with your estate planning attorney, maybe you need more complicated trusts, maybe you need to do some deed work, things like that. But start with that very basic and work from there.
So let's start with the basics of a will. I mean, it seems like it should be a very simple document. And I got to tell you, folks, it's amazing how often people come in and they've gone to places like LegalZoom.com or on the internet someplace to download their own will. And if you decide to go that route, just make sure you read the disclaimer on the webpage, because it says consult an attorney before you do this yourself. But let's talk about the basics of a will. What does it do? How does it work?
Well, a will does a couple of basic things. First and foremost, it controls the distribution of the property that you own at the time of your death that isn't already designated to go to someone.
So for example, I own a home with my wife.
Right.
We jointly own it. So when I pass away, it goes to her automatically.
Automatically, it doesn't matter what you say in your will. If you could say that house goes to someone else, and that's going to be completely ignored in your will because it's going to go to your wife because you and your wife jointly own that home.
And that's operational law.
Exactly.
Okay, and then if I have investment accounts or savings accounts, if I have a beneficiary on that, that's not what we're talking about.
Right.
So what type of assets does the will actually control? Because that's the probate process, right?
Right.
So what assets do the will typically control?
Well, for married people, it typically controls the assets when the second married person dies.
Okay.
For single people, it controls most of their assets unless that single person, which is not typical, but unless that single person put a payable on death beneficiary, transfer a death beneficiary, or added someone as a joint owner with rights to survivorship, which doesn't typically happen. So for a single person, it controls just about all their assets, and for the married, it controls the second spouse to die.
So you create the will, and the idea behind the will is you name a personal representative.
Correct.
And what does a personal representative do?
Personal representative is in charge of probating your estate, of making sure they gather all the assets, account for the assets, and carry out your wishes under the guise and under the supervision of the Register of Wills.
Okay, so we have a personal representative that we've named. They're going to make sure that my stuff goes someplace.
Right.
And we have to name beneficiaries.
Correct.
Okay. And then you mentioned earlier about the children. How does that work in a will?
Well, at least for Maryland, and I think most states that I'm familiar with, you can designate who you want to be the guardian of your children. And the place where Maryland recognizes that designation is in the will of a deceased parent.
Okay. And what about the assets going to kids? Because you know what? I have an 18 and a 21-year-old. I love them both to death. But I'm not sure they're ready to handle $20, let alone a sizable estate.
Right. Well, you can create trusts within your will. Most people think of trusts as something separate from a will, but in fact, there's a testamentary trust, which is a trust created within a will, and you can say, leaving my property to my children who are young age, but I want it held in trust, and you can spell out the terms of that trust within the will. So you don't need to create a trust during your lifetime and fund it during your lifetime for your children. You can, in fact, create and have it there after your death within your will.
So quite simply, the will establishes who's in control of my estate when I die, where it goes when I pass along.
Right.
It does any type of planning to control assets for my kids.
Correct.
And then it does tax planning as well if necessary?
You can have trusts within your will that create for tax, to have certain tax advantages, particularly estate tax advantages, by creating separate pots of money, if you would, under one will that won't later get taxed at the death of the beneficiary.
And so basically, if you're in a state that has estate tax, and like I said, it's about 2/3 of the states out there have a death tax of some sort. So regardless if you have $5 million, which is the federal exemption, if you have any type of estate, you want to make sure you discuss, do I need estate tax planning in the state in which I live? Some states have two types of taxes. Some states, like Maryland here, we have an estate tax and an inheritance tax.
That's correct.
What's the difference between the two?
An inheritance tax is a 10% tax that they impose if you leave property to people who are not close family members.
Okay.
And that-
so if I leave money to my children or my brothers and sisters, no inheritance tax.
There's no inheritance tax.
But there may be an estate tax.
You have more than $1 million that you're leaving total to everybody and their non-spouses, then there's a 16% tax on the total amount in excess of $1 million, regardless of who you leave it to, as long as it's not a spouse.
So estate tax is the right to give the money away. Inheritance tax is the right to receive it.
Correct.
We're going to take a quick break here. When we come back, we're going to talk about the other documents that you need to have for a sound estate plan. You're watching The Savvy Investor, and we'll be right back.
If you're in retirement or retiring in the next 3 to 5 years, you must read Michael Canet's best-selling book, Surviving the Perfect Storm. Best-selling author and National Quill Award winner, Michael Canet's Surviving the Perfect Storm is a must-read to prepare for your golden years. This amazing book can be yours absolutely free, but you must call 800-787-SAVVY. Supplies are limited, so be one of the first 25 callers to receive your free limited edition autographed copy of Surviving the Perfect Storm. Call 800-787-SAVVY. Join the host of the nationally syndicated TV series, The Savvy Investor, and best-selling author Michael Canet for this very important, life-changing workshop. Michael and his team of advisors from across the country have been helping families create and live the retirement they envision by carefully crafting a retirement income plan that can withstand any financial crisis. Michael will give you the tools you need to make sound investment choices and help you prepare for your golden years. At this workshop, you will learn more than just where to invest your money. Michael will also share tax strategies that can save you and your family thousands in tax dollars. You will learn important estate planning techniques that can help you avoid the high cost of a nursing home, as well as reduce or completely eliminate any estate tax. Now, you can join him in person for these very informative workshops. They could be the answer to creating a safe and secure retirement you deserve. Call 800-787-SAVVY to see if you qualify to attend one of these workshops with best-selling author Michael Canet, host of The Savvy Investor.
Welcome back to The Savvy Investor. Today we're talking about estate planning with estate planning guru Chester Hobbs. Now, before we took our break, we talked about the ins and outs of how a will works. And we said we're going to get to powers of attorney for financial matters, the advanced care directive, and the living will. But before we go there, I want to address some viewer mail. Now, we have a couple things on hand here. Matt from Columbia has written us, and he's asking about joint accounts. Evidently, he went to the bank, and the bank people told him to put his name on his account with his father so that if he needed access to the money, he could get to the accounts. There's some problems with that.
There's some problems from that, and particularly from the father's standpoint. Going back to what we were saying about a will, if the father has a few children in addition to Matt, and he's wrote a will that says, I'm leaving everything to all of my children, well, he's just shot himself in the foot because that account is no longer subject to the will if his son adds his name to it.
Because Matt gets it all.
Because Matt gets that account.
Right.
It bypasses the will. Right. There's an easier way and a better way to achieve the same goal. Matt can go on that account as a power of attorney, have full signing authority. If Dad wants Matt to get that account, in fact, instead of having joint ownership, he could put Matt as a transfer on death beneficiary. And the advantage to that is if Matt ever got sued during Dad's lifetime, if he's a joint owner, that subject is subject to the creditor's claims of Matt.
Right.
Whereas if Dad owns it wholly and only passes after death to Matt, it would be better to do it with a transfer on death TOD or POD designation.
So Matt, the simple answer is that your name should not be on an account with your parents at all. If you want to have access to the account to help them out, a power of attorney works, and we're going to talk a little bit more about that. And if mom and dad want to leave you the money when they pass away, and they want to do it by operational law, the TOD, the transfer on death, is the way to do it. We're going to go to our second email here, Micaiah in Denver. And evidently, she has attended a revocable living trust seminar, and the attorney there has recommended a joint trust for her parents as opposed to two individual trusts. And her concern is that her parents have individual trusts. So why a joint trust versus two individual trusts? Is there a better solution or a better approach?
Well, I think, it had been the sort of standard had been individual trusts. I think a lot of attorneys, including myself, are moving to joint trusts. Most states are enacting recent legislation extending the creditor protection of tenants by the entirety. Marital property is typically owned tenants by the entirety and has certain creditor protections that other properties don't have.
For example, your house. To protect
Exactly.
Your house. Right.
And so what was happening in the typical way of doing it when they were recommending separate trusts, you were severing, even though you had the tax benefits and the trust benefits and very good estate planning goals achieved by the separate trusts, you were losing the creditor protection. And now you
Because you had to bifurcate.
You had to bifurcate the asset
the
into
residential,
two,
the
right.
personal residence. Right.
And so from a property law standpoint, you lost that protection. Well, states are rapidly enacting laws that allow trust to protect tenants by the entirety property. It has to have a special tenants by the property clause in the trust, and tenants by the entirety property has to be donated jointly by the spouses directly to it. But in that way, if that's the reason that they're recommending a joint trust, it probably is preferred.
So in Micaiah's situation here, if her parents already have two single trusts, is there a solution other than redoing the whole trust and just making one joint trust?
Not if the goal is to get tenants by the entirety property, you actually have to deed the property out of the joint trust back to them individually as tenants by the entirety, and then redeed it back into a joint trust. I'm not sure, again, we don't have a lot of the facts in this question to know what the motivation is. That really is the only motivation I could even think of to undo their current plan.
Right.
To redo it as a joint trust. Other than that, it just seems, like we're chasing our tail a little bit.
Right. So Micaiah, depending on the facts and circumstances, it may or may not make sense to actually redo the whole entire estate plan and create a joint trust for mom and dad. But it really is just facts and circumstances.
Absolutely. So we need to know more about that.
All right. So great viewer mail. We appreciate it. Now let's get back to the other documents. We talked about wills and why wills were necessary and how they worked, but there's a couple other documents. Let's talk about the financial power of attorney.
Right. Financial power of attorney would be something that you would execute while you're healthy, while you're competent, in anticipation that at some point in time before your death, you could become sick or incompetent, unable to handle your financial affairs. And what would happen in the financial power, you would appoint the person you'd want to be that financial representative and maybe an alternate or even a second alternate in anticipation of that possible future event.
Somebody to make financial decisions for me when I can't make them myself.
File for benefits, file your tax returns, withdraw your bank account. If you couldn't live in your house anymore, sell your house and get you suitable housing if you needed something on one floor in the future. Right.
Okay, so that's the financial power of attorney. Now, there's also the healthcare powers of attorney. Right. And there's really kind of two sides to those. There's the Terry Schiavo live-in will and the Advance Care Directive. And even though for most of us we think of them as kind of one document and they work together, they are two separate documents.
I draft them as two separate documents and recommend they are two separate documents.
So the Advance Care Directive, let's start with that one.
Advance Care Directives is something you would typically use to appoint your healthcare spokesperson. If you could not communicate with your doctors, you want to designate who in your family, who in your life is the person who would carry out your wishes, make choices for you medically that you would make for yourself.
But no, this isn't, the Advanced Care Directive isn't when I'm dying. It's just when I can't or are unable to make medical decisions myself.
Exactly.
I'm old and I just don't want to make them. I just need the assistance.
Right. Or you're not terminally ill. We're not talking about removing ventilators, but yet you're unconscious or you're being treated. And should we have some sort of surgery to help you and to get you to recover, you couldn't consent to that. Somebody needs to consent to that.
Okay. And then the live-in will?
Only deals with that terminal end stage event. Should we or should we not remove ventilators and respirators? And should we or should we not remove feeding and hydration tubes? Your living will, and I see a lot of times living wills that are silent on the issue of feeding and hydration tubes. when it's silent, there's a presumption that you must keep feeding in hydration tubes. So if that is not your intention, I highly recommend that you have your living wills reviewed to make sure that they are specific that you do not want feeding in hydration tubes.
So, I mean, the living will, to me, is probably one of the most important documents that people ignore. And really what you're doing is you're taking the onus off your children to make end-of-life stage determinations for you. And it's a really difficult thing for kids to do. I mean, if you think about it, they have unresolved issues with mom and dad, and we're at the point now where we're deciding whether to pull the proverbial plug. And you need, as parents, you need to guide your children in this decision-making process. Now, a lot of people know that most states, or many states, have laws that basically the family gets to make the decision. And the fact is that's true, but hospitals can't fix dead, so they will not pull the plug unless the whole entire family agrees to what's going to happen. And we saw down in Florida with Terry Schiavo what a catastrophe that was, because the parents wanted one thing, the husband wanted another thing, and we had years and years and hundreds of thousands of dollars of legal battles. So you need the living will done, you need the advance care directive. How often should they update the powers of attorney?
They should have them reviewed every few years, 2 to 3 years. If nothing else, they should re-sign and re-execute and re-notarize and say these are still valid on this date, because older powers of attorney have a larger chance of being rejected.
Right. So every 3, 4, 5 years at the max.
Have them reviewed, maybe update them. If they don't really need any updating for legal reasons or you haven't changed the people you want to act, at least re-execute and redate them as fresh and valid.
So there we have it, folks. We're going to take a quick break, and when we come back, we're going to recap the things you need to know about estate planning. You're watching The Savvy Investor. I'll be right back.
Now keep in mind that just like any tool, there's the right tool for the right job and a wrong tool for the wrong job. We've just scratched the surface here, and you'll want to know more about how today's conversation might or might not fit your needs. Ask about fees, surrender charges, market risk, interest rate risks, how the guarantees work, liquidity, and much more. Remember, the right tool for the right job.
If you're in retirement or retiring in the next 3 to 5 years, you must read Michael Canet's best-selling book, Surviving the Perfect Storm. Best-selling author and National Quill Award winner, Michael Canet's Surviving the Perfect Storm is a must-read to prepare for your golden years. This amazing book can be yours absolutely free, but you must call 800-787-SAVVY. Supplies are limited, so be one of the first 25 callers to receive your free limited edition autographed copy of Surviving the Perfect Storm. Call 800-787-SAVVY. Join the host of the nationally syndicated TV series, The Savvy Investor, and best-selling author Michael Canet for this very important, life-changing workshop. Michael and his team of advisors from across the country have been helping families create and live the retirement they envision by carefully crafting a retirement income plan that can withstand any financial crisis. Michael will give you the tools you need to make sound investment choices and help you prepare for your golden years. At this workshop, you will learn more than just where to invest your money. Michael will also share tax strategies that can save you and your family thousands in tax dollars. You will learn important estate planning techniques that can help you avoid the high cost of a nursing home, as well as reduce or completely eliminate any estate tax. Now, you can join him in person for these very informative workshops. They could be the answer to creating a safe and secure retirement you deserve. Call 800-787-SAVVY to see if you qualify to attend one of these workshops with best-selling author Michael Canet, host of The Savvy Investor.
We were joined today by Chester Hobbs, estate planning attorney, and he gave us some very significant takeaways from today's program. First and foremost, he explained to us that we need some basic documents. We need the will, a power of attorney for financial matters, advance care directive, and a living will. Now, those are necessary documents that each and every one of us needs. The second takeaway we have from today is that you want to try to avoid probate to the extent possible by using transfer on death accounts and reviewing your beneficiary forms on a regular basis. Now, the third takeaway from today's show is that estate tax planning is necessary for most of us across the country. It's a few little steps you have to take, but with some special planning, you can avoid estate taxes in almost every state. And finally, if you would like our step-by-step guide to estate planning, call the number you see on your screen and we'll get you out a free copy of the steps you need to take in order to create a sound estate plan. Next week on The Savvy Investor, we're going to be talking about income planning, the things you need to do to ensure that you have a sound income during your retirement years. We'll see you, The Savvy Investor, next week.
If you're in retirement or retiring in the next 3 to 5 years, you must read Michael Canet's best-selling book, Surviving the Perfect Storm. Best-selling author and National Quill Award winner, Michael Canet's Surviving the Perfect Storm is a must-read to prepare for your golden years. This amazing book can be yours absolutely free, but you must call 800-787-SAVVY. Supplies are limited, so be one of the first 25 callers to receive your free limited edition autographed copy of Surviving the Perfect Storm. Call 800-787-SAVVY. Join the host of the nationally syndicated TV series, The Savvy Investor, and best-selling author Michael Canet for this very important, life-changing workshop. Michael and his team of advisors from across the country have been helping families create and live the retirement they envision by carefully crafting a retirement income plan that can withstand any financial crisis. Michael will give you the tools you need to make sound investment choices and help you prepare for your golden years. At this workshop, you will learn more than just where to invest your money. Michael will also share tax strategies that can save you and your family thousands in tax dollars. You will learn important estate planning techniques that can help you avoid the high cost of a nursing home, as well as reduce or completely eliminate any estate tax. Now, you can join him in person for these very informative workshops. They could be the answer to creating a safe and secure retirement you deserve. Call 800-787-SAVVY to see if you qualify to attend one of these workshops with best-selling author Michael Canet, host of The Savvy Investor.